Hello everyone, welcome back to the It's Cult edition of the Darrell Brooks saga. Today we're gonna start day 13. Um, it's gonna be a really interesting day because this is when the when he blows up basically because he's done. He's basically done with his defense. So let's say they help him move on from that. Alright, before that, let's just say thank you for watching. Thank you for subscribing if you're not subscribed, and thank you for giving it a like. It's a really small thing. It's a really small thing that you can do, and it really helps the channel a lot. So thank you for doing that. All right, let's get into the video.
May I have the appearances, please?
Morning, Judge Sue Upper, Leslie Basie, and Zach Witchell appearing for the state of Wisconsin.
I'm here as a third-party intervener
Oh,
in the matter
God.
of being as authorized representative for my client.
I know that he's doing his thing, but I'm just gonna pull out this real quick and say that that is an awful combination. That's a zero. That's just a zero. No, the yellow shirt, the blue tie, or purple, I don't know. No, it's a 0 plus -2 from being Darrell Brooks, so that's a -2 today. It sucks.
I accept for value and return for value all of the charging instruments in this matter and make my exemption available for the discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and make a reservation of all my rights here this morning. All rights reserved.
All right, good morning to you as
All rights reserved? He just said that twice? He's like, I reserve all my rights, all rights reserved. It's like a movie.
well. The records reflect the individual known to this court as Darrell Brooks is present in person in custody. However, he is wearing street clothes, a suit and tie, and a mask.
And for the record, I don't consent to being called that name.
It is noted. All right, Mr. Brooks, just preliminarily, do you anticipate calling any additional witnesses today?
For the record, I don't consent to being called that name. And what was the question?
Do you,
What was the question? My guy's not even listening. He's more worried to saying about not being called his name that the question.
anticipate calling any witnesses today?
I don't believe today.
So when? In a week?
Well, we are here for the continuation of testimony. The only witness that I'm aware of that's on your list that you added is your mother, Dawn Woods. So I would expect that if she's going to testify, she would be here. Otherwise, I will be going through the colloquy with you as to whether you intend to testify today or not.
Did you receive my ICS that I addressed?
Can you imagine if he testified? That would have been something else.
To you?
Oh, I haven't looked. Let me look. Do you know when you sent those?
Saturday. So that would have been the 22nd.
State receive anything through like the inter-office communication?
We have not, I just checked this morning to see if there's anything new. Nothing has been received at my office. And I should say the clerical that was assisting me went to the mailroom to double check. So not only has it not made its way to the DA's office, it hasn't even made its way over to the mailroom.
I definitely want those documents received that they obtain important information.
About
You
what?
said you forwarded them to a staff member on Saturday?
Yes.
Do you know if that was morning, afternoon, or some other time?
Maybe afternoon.
Alright, I'm sending that. I will send it with high importance and we'll see what response I get. But I don't have anything. If you want to generally tell me the topic, we can cover it verbally.
I believe that a Brady claim should be visited because there were in fact recalls on that vehicle.
Okay, this is the day when he argues that it was a vehicle malfunction what made him do this. I don't know what he wouldn't offer this as a defense in the first day, but here we go.
In fact, there were recalls on the Ford Escape models from 2008 through 2010 in regards to the throttle body malfunctioning and causing the vehicles to accelerate and not being able to be stopped. There is a class action lawsuit where Ford Company were sued because of this, and those vehicles models from the year 2008 through 2010 were recalled, and that is very important information in regards to the vehicle in question being a Ford Escape 2010. Because of this malfunctioning throttle body, for I believe it's counts 1 through 73 to be dismissed.
All right, so he wants all of his charges dropped because he found out that there was recalls on some Ford Escapes, even though there was what do you call it? A full inspection of the vehicle, and it was determined that there was no malfunction with the vehicle. So I don't know what he wants. The fact that some cars were recalled because of that doesn't mean that his was. He needed to recall his.
All right, what's the response from the state
Oh,
defendant?
his mom's.
Consistent with our research, there are no active recalls listed for the Ford Escape. As Trooper Inspector Schultz noted during his testimony, basically the electronic throttle body failures would have resulted in engine stall or surge while entering traffic from a stopped position or while driving at highway speeds, neither of which I believe occurred here. Further, Inspector Schultz would testify that that does not prevent the brake from working. So if this had been activated on this car, which it was not, but if it had been, and this defendant would have pushed down on the brake, it would have stopped the car. Further, running the defendant's mom's VIN number through NHTSA, National Highway Traffic and Safety Administration. There are, for this particular VIN number, for this car that the defendant was driving, 0 unrepaired recalls.
There you go.
So it's a moot issue.
I don't believe it's a moot issue, and I actually have. The report should be in the mailroom as we speak. I had everything sent over priority mail. The actual information about the class action lawsuit, the actual information about the recalls for those models, like I said, 2008 through 2010. Now, in all fairness, Your Honor, that's why I was asking for a Brady claim on this, seeing as how when vehicles are purchased from the manufacturer, they're still sold as is. There would be no way to know that there's anything malfunctioning with the vehicle until it actually happens.
All right. I think this is the point where he destroys his own argument. Like, Leslie Bassey just did a great job at just saying that it's not gonna work. But he also right now, he just said you can't know if something is malfunctioning until it happens. Okay, let's say it happened. Then it wouldn't shown in the report, in the inspection. So what are you saying then? You just said that. You just said that, and it's a mute issue then. It didn't happen. It would have shown in the inspection.
And seeing this a class action lawsuit, no one would sue the Ford company if there weren't malfunctioning vehicles. There would be no class action lawsuit if these vehicles were not malfunctioning. And I believe with that, the information about the malfunctioning pertains strictly to the throttle body.
Let me address your claim, sir. So, not trying to cut you off, I don't need the specifics about a class action, because as it relates to this case, the fact that there's a class action would not mean there's a Brady violation by the state. In fact, you even indicate it was readily known and something you were able to find out. I'd further note that you had a full and fair opportunity to cross-examine the inspector regarding his mechanical inspection. It's not new information. Again, there was a full inspection. That report was provided to you. He testified on direct examination about there being no active recalls, and more importantly, he testified about what impact the throttle body would have and what he would expect to see if there were any issues with it. I am aware that the ICF, I did receive an email, it's one page with what you said. I have to turn my head, I gotta figure out how to flip it.
You just right click and rotate, Judge.
A second.
Okay. And just for the record, Your Honor.
Hold on, let me finish my record, okay? So I'm going to turn, because it's the only way I can read. It says, your ICF says the state's expert witness who did the inspection on the vehicle in this incident needs to be recalled no later than Wednesday. I just learned of some information that is extremely vital. I understand the information that you're providing me, but again, you had a full and fair opportunity to cross-examine this witness. This information was apparently well known. I'd also note the vehicle's registered to your mother, and from my understanding of recalls, I think what is common knowledge is that a registered owner would receive information regarding the recalls and what to do, and presumably she would have provided that information to anyone operating that vehicle or taking care of it. We have none of that information before us by way of fact or even an offer of proof that even she received that information and did nothing with it, or whether anyone else who operated that did anything with it or not. And from my understanding and review of Exhibit 83, what's important to this case is that the mechanical inspection specifically looked at that issue nonetheless and found that as to this particular vehicle, there were no issues with that. Again, without anything further from you by way of your offer of proof, I can't make a finding, number one, that there's a Brady violation, and number two, that the information you seek to cross-examine him on would have any impact whatsoever. So I'll deny the request to dismiss the case, and I'll deny the request to recall this witness.
Your Honor.
Hold on. Let me have the state just make their statement. I'll give you the last word on it. Go ahead.
The Inspector Schultz's mechanical inspection report was provided to the defense on April 29th, 2022. I noted that when the defendant was cross-examining Inspector Schultz, he did have the report in front of him and it was asking questions directly related to information contained in that report.
Yeah.
All right, go ahead.
He was basically reading from the report and asking questions about it. So he had it. He didn't read it before, obviously, but he had it.
When you spoke to the owner of the vehicle, that's who gave me the information. My mother gave me the information of this. Again,
you keep saying Dan Woods is your mother. Dan Woods has one son, and it's called Darrell Brooks. So are you Darrell Brooks?
I had no knowledge until she told me. And that's how I came into the information. And she was the one that said, I'm going to send you all the information that you need so you can present it to the court.
He always needs the help from someone else. Mostly his mom.
So
I understand that, sir, but your request is not timely. So you have had this information for quite some time, either through counsel.
I did not have it for quite some time.
Let me make my record. Either through counsel.
It was just told to me.
That's not what I'm saying.
Not that one. Not about the class action. It's about the report.
had the information about this report for quite some time, either through prior counsel or through all of the discovery that was turned over to you when you took over your representation of your own case. The fact that you have now learned this, it's a little bit too late. You had a full and fair opportunity to cross-examine the inspector about information that was readily obtainable and researchable by you prior to the time that you cross-examined this witness.
It was not readily available for me to expect at the time. I don't have access to the internet. So how would I be able to?
Mr. Brooks, you're telling me your mother had that information.
No,
so,
I'm
and
telling
I'm
you,
gonna
she just told me this information. I have the phone calls to prove it.
I understand that. I'm denying the request, sir.
There you go.
And I would like a.
So that's my decision.
I object to that, Your Honor.
He was so sure that this was gonna work. Like, he was so sure that with the class action lawsuit, that's all that she needed to revoke all of the hidden people with the card charges. And it didn't work. Let's see how he reacts to that now.
I understand.
I
I've made my
object to that.
decision. I expect that you respect the decision, at least
No.
as we're not going to debate it further.
Yes.
I now have the
It needs to be-
ICF,
it
the
needs to
one
be
for the state
addressed,
that
Your
we provided
Honor.
for the state.
It's been addressed. She just addressed it.
Madam
needs to
Clerk,
be
I just gave
addressed.
that to you.
She just did.
All right, so
I
Mr. Brooks, in
respectfully
light of
object.
that,
I respectfully object, Your Honor, and request a legal reconsideration of your ruling, Your Honor.
it's denied. The request for reconsideration is denied. There's no legal basis for me to do
I
that at this point.
respectfully reject that ruling and take exception to that ruling, Your Honor.
All right, Mr. Brooks, we need to keep going.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
I provided an oral ruling today. The record stands, sir.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue?
Your request is denied.
For the record, may I respectfully move for an interlocutory declaratory appeal of this matter?
No.
I wouldn't be the one you would make that request to, sir. So I
For
can't
the record, may I
answer that
move
yes
to
or
stay
no.
these proceedings until the instant matter is adjudicated by a court of competent jurisdiction?
That request is denied.
Based on what law or fact, Your Honor?
The request is denied.
Based on what law or fact,
What,
Your Honor?
any other requests, sir? I'd like to move on.
Based on what law?
There's no
Or
legal
fact.
basis that you've stated for me to do that, sir.
It has been, Your Honor.
The request is denied. The request is not a proper motion. There's no legal support for the motion. There's no factual support for the motion. So it's denied.
For the record, it appears that this court is acting in contempt of the law, Your Honor.
Just for not granting your request.
Can you show
Things are not going well for me. That means that you're cheating.
me how or where this court is following the law of respecting this matter?
No.
That's a very vague statement, sir. There's no legal relief that you're claiming. There's no motion before the court based in law or fact. So this court cannot address that last statement of yours.
Your Honor, with all due respect, I would like a motion for finding the fact.
Denied.
Under what law fact?
I
Your
made
Honor?
an oral ruling, sir. There's no requirement. I do so in writing.
There you go.
So you're denying a legal, denying a motion for finding the fact.
I am.
Yeah.
So how do I know what you're doing is legal, Your Honor?
You should. No.
All right, Mr. Brooks, we're going to move forward. At this time, I want to,
How do I know that this is legal, Your Honor? Can you show me that it's legal?
Mr.
No.
Brooks, we're moving forward. So your
Doesn't
request
seem
is
like
denied.
it doesn't seem
Mr.
like
Brooks,
you're-
I need to give you some
It
advisements,
doesn't
and I'd
seem
ask
like
that
you're.
you
I
stop
don't need
interrupting
your
me.
advice.
No, I have to
need
give you
you-
advisements, sir, regarding
I
your
need
right
you
to testify.
I need to do your job without prejudice and without
Mr.
bias.
Brooks has
Your
now
Honor.
interrupted me multiple times. He's failing to respect the court's oral rulings here today. It's something that he's done repeatedly throughout this trial. Mr. Brooks, I need to go through some advisements. Unless you have a witness to immediately call, I need to go through this particular discussion on the record with you regarding your right
You don't-
to testify.
You don't need
Do you
to
have
go
a
through-
witness
you
to
don't
call,
need to go
sir?
through anything with me on record.
Yes, you do. Yes, she does. You need to know. She needs to know if you are gonna testify. You cannot stall that.
Actually, I do so,
Actually,
sir.
you
That is
don't.
required by
Actually,
law.
you don't. You need to do your job as a public servant
Mr. Brooks,
and honor the oath that you
I
took,
need to
Your
go
Honor.
through these advisements, and if you're going to keep interrupting me, you will forfeit your right to be present, and you
So
will
you're
be
holding me in
removed
contempt
to
again.
Take him out.
the next courtroom so that I can properly go through these advisements
And
without
I
being
still
interrupted.
And I still don't have to answer. I still don't have to answer whether
Yes, you have to answer.
I'm in this court or not. So you're holding me in contempt yet again.
Mr. Brooks, I've not held you in contempt.
With
I
all
need
due
you
respect, in
to
Illinois
not
versus
interrupt
Allen,
me.
in
This is
Illinois
another
versus-
interruption.
In Illinois versus Allen.
Mr. Brooks,
do
I'm
they
not
say-
going to have a debate with you on
I'm
the
not
meaning
trying to
of
have a
Illinois
debate.
versus
I'm not
Allen.
trying to have a debate.
You
I'm
are
merely
advised
trying
that
to
it
understand
continued.
Illinois versus Allen.
Mr. Brooks, you are advised that continued interruptions will result in you forfeiting your right to be present during this next phase of the trial.
Okay, but
Okay.
you saying that I'm
I've said
forfeiting
that
my
multiple
right.
times.
You
I've
saying-
given you multiple
You're
opportunities to
holding
stop
me in
interrupting
contempt.
me.
You're holding me in contempt.
Mr. Brooks,
By
I'm not holding
removing
you
me
in
from the
contempt for
courtroom.
the second time here, and I've
Your
also
Honor.
repeated that.
Your Honor,
He's
with all-
interrupting me yet again.
with
Mr.
all
Brooks, I
respect-
need you to stop talking.
With all respect, in Illinois versus Allen.
All right,
Did he just say Illinois? That's not how you say that, I think. Digo, I mean, I'm a second language, but I know that's Illinois. You don't say the S at the end.
Mr. Brooks continues to want to debate with me the meaning of Illinois versus Allen. It is a clear indication to this court
trying to
that
understand,
he
Your Honor.
wants to disrupt these proceedings, even
That's
in
not
a
true.
mild manner tone
That's
of
not
voice.
true.
I've
I'm
reminded
seeking
him
to
repeatedly
understand, Your
regarding
Honor,
the standards
because
of
it
decorum and
doesn't-
civility, and
Illinois
one of the
doesn't
bedrocks is that
Illinois
he not
versus
interrupt.
Allen does not state.
All right, I'm going to
that-
remove him to the next courtroom so
Thank
that I
you.
can go through
It does
proper
not state-
advisements with him without being
It
interrupted.
does not
We'll clear the
state
courtroom
that
and
you
we'll
can be
resume
present from
once he
cameras.
is over there. Again, I'll
It
make
doesn't
the
state that
appropriate
you can be
findings when
present
he is
from
there.
cameras, or that you could be,
Yes, we're off the record.
or that you
until,
could be.
he's in the
Okay,
other
so
courtroom. I'll
you're
be
making a
stepping off.
tacit agreement.
Okay, so he doesn't like that she gets him out and put him in the other courtroom with cameras and audio to that. So what does he want? He wants her to remove him and send him to jail and just keep on with the trial, because that's the third option in Illinois versus Allen. Versus Allen. So that's what he wants. He doesn't want to be there at all.
For something that I
All right, thank you. I do have verification. There are headphones on the table in front of Mr. Brooks should he choose to wear them. I see he's reading from a book at the moment. I do need to make a record that this morning, although Mr. Brooks was not raising his voice, there were repeated interruptions. He wanted to debate rulings that I made after the fact. Just this morning alone, about 26, 27 different times he interrupted me or spoke over me. I advised him that if he continued, he would forfeit his right to be present in this courtroom and would be taken to the neighboring courtroom. I believe I gave that warning at least twice. I do appreciate that this morning he didn't yell at me, he didn't raise his voice, he didn't speak in an angry tone. But given the history in this case leading up to today and knowing what this court needs to get through in terms of whether he has any witnesses or whether he intends to testify himself, there's a very important colloquy I need to have and an advisement of his rights that I need to go through, and I simply am not able to do that with him constantly interrupting me. And of course, last Friday was, in my opinion, probably one of the most challenging days, I should say, to date. Mr. Brooks, you have been muted. I will make that, put that on the record as well. I will unmute though and ask Mr. Brooks, because you did not answer the question previously. Other than you potentially testifying on your behalf, do you have any other witnesses present at the courtroom, at the courthouse to call today? I need an answer to that question, sir.
It's a no.
subject matter jurisdiction that we haven't addressed when I was just over there, or since I've been over here? Are we addressing subject matter jurisdiction?
I'm going to mute him just for a second. No, I'm not going to address subject matter jurisdiction. This is a common ploy by Mr. Brooks. When I attempt to go through certain things with him, ask him questions, he tries to divert our attention away to subject matter jurisdiction. I have issued a written decision on that. He has not filed any type of interlocutory appeal regarding that. This court's position is there is subject matter jurisdiction, and I'll deny verbally and orally at this point his request to dismiss the case based on a lack of subject matter jurisdiction. Mr. Brooks, I will be asking you a couple of questions. I do need a response. I am unmuting you. Do you have any other witnesses other than yourself available at the courthouse to call this morning, meaning now?
Now.
This is the jurisdictional challenge right here.
She already addressed subject matter jurisdiction in a written form, and you had it twice. So, she already addressed it.
So are you going to address subject matter jurisdiction and prove it for the record or not?
So I've asked Mr. Brooks twice now whether he has any witnesses to call other than himself. He has declined to answer that question. Sir, if you fail to answer that question, I will interpret your failure to answer that as a no, and you will lose the opportunity, you will forfeit the opportunity to call any other witnesses on your behalf other than yourself. So I will ask you one last time, sir, do you have any other witnesses at the courthouse available to testify right now? I'm not getting a response at all.
Am I unmuted?
You've been unmuted, sir.
You just said I was muted, so I'm not sure. I don't know when you muted me or when I'm not muted.
Well, me muting you doesn't affect you being able to hear the court because...
He also sounds really low because he has his boxes covering the microphone. So you can see down there, the microphone is covered by that white box.
That only mutes your audio coming into this courtroom. I confirmed already
Why is my
that
audio muted to begin with?
that is simply a misstatement. I confirmed with the bailiffs that the audio and visual were working.
Why is my audio muted to begin with?
Because you interrupt the court repeatedly. So I'm going to ask you yet another way, even though for 3 times now he has failed to answer this court. You indicated last week that you would like to call your mom as a witness, Dawn Woods. You were provided with notice that the state would not be assisting with that in any way. You indicated when that was said that if you wanted your mom to testify, she would obey you and she would be here.
Yeah.
So I trust that you've made arrangements for her to be here. Are you going to call Dawn Woods as a witness this morning and specifically now?
Again with the pain.
I will ask him a second time, sir. Do you have Dawn Woods available to call as a witness this morning? He's been unmuted though, for a while now. We can obviously hear him. I will ask Mr. Brooks a third time for the record. He's finally putting on the headphones. Is Dawn Woods in the courthouse available to testify right now? Do you intend to call her?
Hold on.
Right?
For the record, Mr. Brooks only puts on the headphones when he's in the other courtroom. He does not put them on when he's in here. The audio and the visual work just fine in that courtroom.
When I'm in the actual courtroom, I can hear. I don't need to be muted.
Mr. Brooks's statements that the audio doesn't work when I mute him is simply false.
I didn't say nothing about the audio not working, so you need to stop lying on the record.
I'm not lying on the record, sir.
You are lying on the record.
All right, I'm going to mute him once again because now he's raising his voice. Now he's angry. He's thrown the headphones. He certainly does not seem to want to answer any of the questions this court has. I asked him 3 times if he had any additional witnesses to call. I warned him that if he did not answer that question, he would forfeit his right to call additional witnesses, other than perhaps himself. I then specifically asked him about Dawn Woods, because that is the person he indicated he wanted to add to his witness list last week, and I granted his request to do that. I asked him twice. He did not respond to that. Based upon his failure to respond, based upon this court advising him that if he failed to answer that question, he would forfeit his right to present any additional witnesses, again, other than perhaps himself, I'll find that he has forfeited his right to present and call any additional witnesses based upon his conduct in this case. I would like to go through a number of advisements with Mr. Brooks regarding his right to testify. I will unmute him for that.
Yeah, he's basically done. He cannot even call Dawn Woods anymore. So he is the only one left to testify.
I asked Mr. Brooks to put on his headphones if he is unable to hear me, and just to be 100% safe and secure on the record, I'd ask the bailiffs who are over there to advise him. I'm going to directly be speaking with him, and if he's unable to hear me, to put on the headphones at this point.
No excuses.
He's unmuted. I've also been advised by not just the bailiffs who are over there, who I can hear through the audio, but also from the clerk who's in that courtroom, through my clerk who's in this courtroom, that the audio is very loud and clear.
He still doesn't wanna.
I will advise you that if you refuse to answer my questions, refuse to acknowledge me, you can forfeit your right to testify on your own behalf. Mr. Brooks, you need to be aware and are so advised that you have a constitutional right to testify. Did you hear me say that? There's no response by Mr. Brooks, and he does not have the headphones on, and he has a book in front of him, although I haven't seen a page turned. If you testify, sir,
He doesn't need to. It's a prop. He's just staring at it.
the state has the right to cross-examine you. That means to ask you questions after you give your initial testimony. Did you hear me advise you of that?
You see, he lifted the book. Like he lifted the Bible so she can see that he is in fact changing pages. Yeah, I don't believe that's true.
No
But
response by Mr.
he's
Brooks.
doing this.
Sir, you
He's
also
like-
have a constitutional right not to testify. If you decide not to testify, you are further advised that doing so cannot be used against you, and I would so advise the jury. Did you hear me advise you of that? Once again, no response by Mr. Brooks. The decision to testify is for you and you alone to make. Did you hear me say that? There's no response by Mr. Brooks. It's my understanding that Mr. Brooks has the equivalent of a 12th grade education, that he attended school either up to or through 12th grade, and either has a GED or an HSED. There's been some conflicting information on paperwork throughout this case, but I'll find that he does have a high school education. He is currently in custody, of course, at the Waukesha County Jail. I'm not aware of any medication that he has been taking. Sir, have you taken any medication within the last 24 hours, or any drugs or any alcohol?
I don't think so. He's in solitary
I'm
most
not
of the
receiving a
time.
response to that. I'm aware that he's able to read and write English. I would refer back to the record made during my colloquy with him regarding the waiver of counsel and his ability to be aware of rights, his ability to, I made a finding at that point of his understanding And based upon his conduct throughout this trial, including the waiver of right to attorney hearing, I'll make a finding that he has the ability
Look at
and
this. See that?
understanding.
As soon as he hears the waiver word, he's like, "What? What's going on? She's talking to me? Huh?"
He can read, write, and understand the English language.
There you go. He's like, "I'm not wavering anything. I just listened to that."
You've been unmuted the entire time, sir.
So what are you talking about? Is you talking about subject matter jurisdiction and how you going to verify it on record?
So he did not answer my question if the record's not clear about whether he's had any drugs, alcohol, or medication within the last 24 hours. I'll ask him, sir, has anyone made any threats against you to influence your decision on whether to testify on your behalf in this trial? Although he turned and said, "What did you say?" Again, I believe he's fully able to hear this court at this time based upon how the audio is functioning in the other courtroom. He did not respond to that. Has anyone made any promises to you to influence your decision?
You saying. So if you can hear me, I don't hear everything you saying, and you know I don't hear everything you saying. So cut the crap.
Wow, my guy, you don't talk like that. And also, you were advised by the bailiffs to put on the headphones if you want to listen. So it's your own fault that you don't want to do it.
Mr. Brooks is interrupted with very disrespectful words at this moment. I believe that he is feigning his inability to hear and that he's done so throughout this case. There's absolutely no indication. He puts the headphones on when he wants. He takes them off when he wants to. While in this courtroom, he hasn't had them on. He's only used them while in the other courtroom. But again, I've confirmed multiple times that the audio is loud and clear. And his statements that he can't hear, his statements that when I mute his audio, that it mutes his audio, are simply false.
You see, she said that she's lying, and now he has to respond to that.
So
Mr. Brooks, have you made...
Am I still unmuted?
You
Yes.
are, sir. And I'll make a record that per the lieutenant over in the other courtroom, the volume is 2 to 3 times louder than it is in this courtroom.
You need to stop making false records saying that I said I can't hear you at all. I said I have trouble hearing you when I'm over here. That's what I said.
Then put the headphones
so I
on.
would appreciate it if you would make the record clear and correct.
Clearly, he heard me say that for him to make that distinguishing
Yeah,
statement.
I'm sitting right
So-
here. Don't you see me looking all up to the microphone so you can hear me?
I don't have
Or
an
can
issue
hear
hearing
me
you
when
at
I'm
all,
right
sir.
here? Can you hear me when I'm right here?
Yes.
I can. Once again, per the lieutenant who's been in both of these courtrooms, the volume in the adjacent courtroom where Mr. Brooks is at is 2 to 3 times louder than it is in this courtroom. Mr. Brooks, have you made a decision?
What about this courtroom?
Have you made a decision to testify in this case?
Now, have you made a decision to tell
I will ask you again, sir. Have you made a decision to testify in this case?
To address subject matter jurisdiction? Have you made a decision to be impartial? To answer what your name is? To answer if you have a claim against me or
I am
don't
going to
you
mute him
have a
for the
claim
moment
against me?
just because, once again, he's attempting to divert away from what this court needs to do by going through the proper colloquy with him regarding his right to testify. He is asking me about subject matter jurisdiction. He's making statements about this court that are disparaging and about my oath. Again, a clear attempt, in my opinion, to simply stall these proceedings and to disrupt them. I will unmute him and I will ask him for a third time with the understanding that if he fails to answer the question in the affirmative, I will interpret his failure to respond as a no and that he is not going to testify. So once again, I am unmuting him. Sir, have you made a decision on whether to testify in this case? There's no response by Mr. Brooks. I will ask it yet another way, sir. Do you want to testify on your behalf in this case?
Am I unmuted?
Yes, you have been. Sir, do you want to...
How long have I been unmuted? 'Cause you just
Sir,
said
do you want to testify in
you
this
just said you
case?
was muting me when I had the headphones on just a minute ago. You just said you was muting me. So when have I become unmuted? Or did you even mute me in the first place?
Yes.
Mr. Brooks, I'm asking you one last time. Do
didn't
you
ask
want
me
to...
nothing because I haven't heard nothing that you asked. So how you gonna ask me something and then just answer for me?
Mr. Brooks, do you want to
You can't answer
testify?
for me.
All right, I'm
You
going
can't
to
answer for
answer.
me.
I'm going to
You
move
can't
him
answer
again.
for me.
Again, it is very clear to this court that he uses the statement that he can't hear as a means to delay. It's a distraction. It's very evident that he hears this court.
I'm unmuted.
Mr. Brooks, are you aware that you have the constitutional right to testify?
Are you aware that you're practicing law from the bench?
Mr. Brooks, do you understand and are aware that you have a constitutional right not to testify?
I don't understand. No, I don't understand.
Are you aware that you have a constitutional right not to testify?
I don't understand, and I'm not aware. So why are you asking me questions?
All right, I'll do this another way, sir. Sir, you are advised that you have a constitutional right to testify and that if you choose to
I don't
testify,
understand.
that you
I
would
don't
be
understand.
subject to cross-examination by the state. Did you hear me say that?
I didn't hear you say anything. I don't
Wow.
understand what you're asking. I don't.
He's-
See, now he has the headphones, so he cannot claim that he didn't hear her. So now he's just being petty. He's just being a child, basically.
Willfully choosing not to answer that. Sir, you are also advised that you have a constitutional right not to testify.
She can.
With all respect, you've been trying.
Did
to
you hear me say
answer
that?
Questions for, I didn't hear you ask me anything. And
Sir?
I don't understand.
Stop talking and I'll ask it again. Sir,
Can you ask me to stop talking?
She can ask.
I'm asking you to stop interrupting me so that you can hear the questions. Even though I fully believe you hear them, I will attempt to do
I
this
got the
one
headphones
last
on.
time.
You have to hear them. I got the headphones on.
All right, then let's...
Obviously, you can see that.
Once again, Mr. Brooks is being disrespectful. He is
That's not being
blurting out
disrespectful. I'm
information.
saying
He
the
reverts
fact.
back to subject matter jurisdiction. He
stating the
accuses
fact.
this court of not honoring its oath. He just accused me of practicing
haven't.
law without a license. Again,
You
all
haven't.
attempts
No, I said
to
practicing law
deflect
from the
away.
bench.
I'm
I
going
said
to mute him
practicing
once
law.
again.
Thank you.
This court has simply tried to no avail to get Mr. Brooks to answer simple questions. He has done nothing to demonstrate decorum. Again, repeated interruptions. It is, again, from my perspective, simply a tactic on his part to delay these proceedings, to disrupt these proceedings. He reverts back again to things like subject matter jurisdiction, practicing law without a license. Then he makes requests about interlocutory appeals, etc. He is what I would describe as a stubbornly defiant individual who simply wants to say what he wants, when he wants, without a filter, without regard to the rules of evidence and the rules of procedure.
It's true.
There are no other witnesses to present for the defense. Before I bring the jury out, I'll ask the state if you intend to call any rebuttal witnesses.
We have no rebuttal case, Your Honor, thank you.
All right. I would like Mr. Brooks to be brought back over so that he is present in the courtroom when the court advises the jury that the defense is resting. I realize that will be over his objection. I'd ask that he honor that. Mr. Brooks, I'm going to unmute you. If you can pledge to this court that you will honor that ruling and that you won't challenge that directly in the presence of the jury, I will bring you back over for that. Are you willing to make that pledge, sir?
Make what pledge? I'm not making no pledges.
Sir,
You're trying to. You asked me a question. Now I can't answer.
Yeah, no, go ahead, answer.
You're trying to coerce me into violating my right to remain silent.
Correct me if I'm wrong, but the right to remain silent doesn't work like that. You can't just stare. You can just be silent and not address the court. That's not how it works.
How can
That it just means that you cannot self-incriminate. But I don't think that it works the way he wants to.
how can you coerce me into my right to remain silent? So you're not going to protect my constitutional rights? Because I didn't answer nothing that you was trying to ask me before when I had the headphones on, and you can't make a decision for me.
She can.
You can't do that.
She can.
You're violating my constitutional rights.
Sir, if you'd like to testify, then you need to simply go through the colloquy with this court, which I've given you 3 opportunities to do, and you have decided not to.
No, you can't tell me what I decided to do, because I didn't decide to do or not do anything.
Are you
By
willing
law,
to?
Your Honor, by law, you cannot coerce me.
I'm not coercing you, sir.
Well, you're making a decision for me based on something that I did not say myself.
Last Friday, I specifically directed your attention to State versus Anthony. I discussed very briefly at the end of the day on Friday the case law that is relevant on this topic, including State versus Anthony, Rock versus Arkansas, and Chambers versus Mississippi, to specifically put you on notice.
Did you recall what was going on Friday?
Mr. Brooks, I'm going to mute him again. I'm not going to have a debate. I've made a finding. I've given him yet another opportunity. If he's willing to go through the colloquy with the court, he wants to challenge me instead and saying he doesn't consent. I'm going to leave him in the other courtroom. The jury's going to be brought out, and he will remain muted, and I will simply advise them, as I have throughout this case, that he's appearing from another courtroom, and that his appearance from the other courtroom should not in any way be held against him or influence their verdict in any way. I will tell them that there are no further witnesses for the defense, and then I'll ask the state if there is any rebuttal, and then the jury will be excused for the day. I will advise Mr. Brooks that if at any point in time he wants to come back over, he needs to advise the bailiffs, but it does need to be accompanied by a pledge. All right, let's have the jury brought out.
She wants to refute what she said, but he can't. She's muted, and he's gonna remain muted.
Thank you, everyone. Please be seated. Ladies and gentlemen of the jury, at the moment, Mr. Brooks is appearing from another courtroom. This must not be held against him in any way and must not influence your verdict in any manner. At this time, I will advise the jury that the defense case is rested, and I'll ask the state whether there's any rebuttal evidence to present.
No rebuttal, Your Honor.
All right, then with that, I will declare the evidentiary phase of this trial concluded. I'm going to excuse the jury for the remainder of the day so that the parties and I go through all of the jury instructions, and I anticipate bringing you in tomorrow morning. Instructions may very well take most of the day. My hope is to then have the closing arguments and then have the case be turned over to the jurors. If not by tomorrow evening, sometime Wednesday morning or early afternoon. With that, I'll rise for the jury then.
He keeps yelling.
Thank you. Be seated. Before we begin, I will have Teresa print off what at least we do have for both parties. I'd like to take a short comfort break. I'll invite Mr. Brooks to come back over, and then we'll start with that jury instruction conference. We'll take about 10 minutes. Thank you, everyone. We are in recess. Mr. Brooks.
All right. So we just saw his attempt to dismiss all of those charges, and his forfeit. He just declined to present any more evidence, witnesses, whatever. So there you go. Let's see how he reacts to all of this in the next episode. Have a great day. Thank you for watching. Bye-bye.